This is the history of legal issues in special education. My name is Dr. George Giuliani from Hofstra University, and this is part 5 of the lecture. And we wrapped up the last lecture, or part 4, discussing Public Law 94-142, the Education for All Handicapped Children Act. And again, we had addressed that this was now our nation's special education law. This was the first federal law specifically designed for children with disabilities. And everything that our current special education law is based on surrounds Public Law 94-142. Now, what were some of the key provisions of Public Law 94-142? Well, first, it was the first law to clearly define zero reject, which ensures that all children with disabilities, all children, receive a free, appropriate public education, or a FAPE, no matter how severe the disability. Next, it required school system to include the parents and guardians when meeting about the student or making decisions about his or her education, so that decisions made about children with disabilities had to involve the parents in all steps of the special education process. Next, Public Law 94-142 mandated individualized education programs, or IEPs, for every student with a disability. Next, Public Law 94-142 required that students be placed in the least restrictive environment, that when we talk about the education of children with disabilities, that they be educated with children without disabilities to the maximum extent appropriate. This is a concept known as the least restrictive environment, having children with disabilities being educated with those without disabilities to the maximum extent appropriate. 94-142 also ensured that students with disabilities are given non-discriminatory testing to determine eligibility. So when we talk about testing and assessment, the tests that are being used to assess whether a child is eligible for special education and related services have to be non-discriminatory. 94-142 also required due process procedures to be in place to protect families and students when conflicts arise with school districts. And the one final thing to note about 94-142 is that it covered school-age children, which is age 6 to 21 years of age. Now, the Public Law 94-142 over time needed to be amended. We needed to amend the law to make it better. As we went on in years with it, we realized there were things that needed to be done to make the law stronger. And this idea of amending a law and then renewing the law is known as reauthorization. And the reauthorization of the Education for All Handicapped Children Act has happened 4 times since 1975. In 1986, 1990, 1997, and 2004. Now in 1986, we had Public Law 99-457. This was known as the Education of the Handicapped Act Amendments. And Public Law 99-457 focused on preschool and infants and toddler programs. And in 1986, this amendment extended the purposes of the EHA to include children birth through 5 years of age. So again, 94-142 only covered 6 to 21, the school-age population. Now, 99-457 extends that from birth through 5 years of age. So now we would have a federal law that was birth through 21. And Public Law 99-457 established early intervention programs, early intervention for infants and toddlers. And again, early intervention covers birth up to the age of 3 years of age, or birth up to 36 months. And it was originally called Part H under 99-457, and we would later change it to Part C under IDEA of 1997. So 99-457 created Part H, and Part H focused on early intervention programs and also looked at preschool children. Under 99-457, just like we have IEPs for school-age children, we have individualized family service plans, IFSPs, for all families of infants and toddlers with disabilities. So now we had a federal law that would cover birth to 21. Those children birth to 3 would have IFSPs, and everyone 3 to 21 would have IEPs. In 1990, we had a reauthorization of the law again, and again, this reauthorization was designed to amend the law, and we changed the name in 1990. 1990 changed our name to the Individuals with Disabilities Education Act, or IDEA. And IDEA continued to uphold the provisions set forth in 94-142. So all of the provisions I talked about prior were continued to be upheld in IDEA. But there were also two other things that occurred under IDEA. Autism and traumatic brain injury, TBI, became its own classifications, and transition services were also addressed under IDEA. Transition services were designed to help those children for when they were graduating from school. You see, prior to IDEA, prior to 1990, we helped children and we provided children with disabilities with these services under 94-142. But once they graduated, we said good luck, and we didn't have anything in place for these children. And so what we did is we designed transition services so that children who were in the teenage years would now be helped by transitioning them from school to post-school activities. And we'll talk more about that in this course. So under IDEA, autism and TBI became its own classifications, and transition services were also addressed. Notice under IDEA, we changed the term from the previous law, from the Education for All Children, to individuals. So now we have the Individuals with Disabilities, and we changed Handicapped Act to With Disabilities. So now we had a law, the Individuals with Disabilities Education Act. IDEA was again reauthorized in 1997, and in that law, discipline procedures were established, and we changed Part H to Part C. And we reauthorized the law again in 2004, and the official name is the Individuals with Disabilities Education Improvement Act, or IDEIA, the Individuals with Disabilities Education Improvement Act. That is our current federal law, and it's now Public Law 108-446. And if you looked in the legal books, you would find it under 20 United States Code between 1400 to 1482. You don't have to worry about that for this course, but know that it's Public Law 108-446, the Individuals with Disabilities Education Improvement Act. IDEA mandates state and local accountability for the education of students with disabilities, and today all students with disabilities participate in state accountability systems. So what do we know about students with disabilities today? Well, what we know is that 95% of all students with disabilities are educated in general ed buildings. Graduation rates for students with disabilities receiving regular high school diplomas have increased 43% in the past 15 years, and there's been a 24% decrease in high school dropout rates among students with disabilities. Enrollment in 2- and 4-year colleges have almost doubled for students with disabilities in the last 20 years, and more students with disabilities hold jobs after leaving high school than ever before. So clearly we have made improvement from where we were starting back in Brown and working our way through to today. And finally, on the last PowerPoint slide, you'll see a link for a video on where we are after 35 years under IDEA. This ends the lecture on the overview of the history of legal issues in special education.